draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning, everyone, and welcome to a session of oral argument in the 5th District Court of Appeal. As you've already heard, I'm Judge Griffin. To my right is Judge Torpy, and to my left is Judge Jacobus. As you can see, it's a very exclusive club today, for those who are here for oral argument. We only have one case to argue, and it's a civil case, so as you should know, each side has 20 minutes to argue. If you've not argued here before, we have a clock on the lectern, and if you would like, I'll help you reserve time for rebuttal. Counsel can begin whenever you're ready.
Thank you, Your Honor. My name is Carol Anderson, and I represent the appellants, the plaintiffs below. I would like to reserve 5 minutes in rebuttal. I would like to address how the amendment changes the obligations, because the trial judge said that because the obligations and the rights are not changed, therefore there was no substantial change in the amendment that the amendment caused. In order to appreciate the substantial change, we need to look at all 3 changes that the amendment brought about, and we need to look at them in toto. The first thing was, there is a declaration of covenants and responsibilities, and it begins by saying that everything is for the benefit, the welfare, the safety, and the security and the recreation of the residents. It then goes on to say that the purpose of the amenity fees is for certain uses, and all of these benefit the residents. And one of those uses is that the amenity fees would be used to pay utility cost for bills that would be water, electricity, telephone, and gas for the lawn and landscaping of the common areas and the recreation bills, recreation centers. Now you can imagine what a big bill that is. Now that part of the declaration, Article 6, Section 1, was deleted by the amendment, completely and totally taken out. Now, keep in mind that paying those bills was a permitted use. It was a specific permitted use by the declarations. Now, when they took that out of the declaration, the defendants and the developer said, so what? We have another section of the declaration, Section 5 of Article 6, that says that the developer will pay all of those bills that are not paid by the amenity fees, all those that exceed the amenity fees. Well, what that does is, when these bills were a permitted use under the declaration, then the residents had some say-so into the lawn, the water, etc., for the lawn, for the common areas, which means that if the grass turned brown, they had the right to go and say, what about this? What's happening? When he took that out and moved it over to his sole responsibility by the use of excess fees, he was actually making that a personal bill, which means that he could take those bills, and if they were too excessive, in his opinion, he could then take steps to try to reduce those bills. And the way
I don't understand your point, because Section 1 seemed to give the declarant sole and absolute discretion in paying for those expenses. So how is it different now?
It's very different, Your Honor, because everything throughout the declarations, it says that everything has to be used for the benefit, the health, the recreation, the welfare, and the safety of the residents.
Well, I mean, doesn't the declarant have the right, for example, to pay its principal a salary out of these monies?
He would have the right
Under
to...
the original declarations.
Well, no question they would have the right to pay the management fees, but that's not the issue here.
Well, but I'm saying that they have sole discretion in setting the amount of that management fee under the original declaration, right? They have sole unbridled discretion in setting the amount of the management fee.
Well, the management fee, but that's another thing. You see, the reason you have to take these three changes in toto is that the defense counsel in his brief says that the only thing that provides for the calculation of how these assessments are going to be determined is Section 5. I'd have to give it to you.
I have it in front of me.
He quotes it in his brief. And if you read that, there's again, at the top of that, it says this is going to be for the welfare of all the residents. But there's absolutely no methodology for the calculation of the assessment other than what we maintain was the pro rata calculation based upon the fact that in each neighborhood, the people were paying the same amounts of money based upon the expenses for their neighborhoods. But once that is deleted, and that was another change in the amendment, they were saying that this is no longer a pro rata calculation. So once you take that out of there, then you've got the developer being able to set the assessment fees any way he wants to. You've got him with tens of thousands of dollars coming from the amenity fees that were designated for...
I thought the amount of the fee was fixed.
I did too. Isn't the amount of the fee fixed? It was so much money that's in the declaration, and then it increases by the CPI over time.
Your Honor, they said it in the beginning, but it's not increased by the CPI. There's that magic word may in that Section 5. It says they may be increased by the CPI. There's nothing that says that they will be increased by. There's nothing that says how they will be increased or decreased. And so it gives the developer the unfettered right to do whatever he wants to do. And because he took...
You lost me. In other words, I'm looking at one where it was $588. And then there's that sentence that says the annual assessment may be adjusted by the CPI. Isn't that the only way they can adjust it under the original declarations and the new declarations?
Yes, and if you take out pro rata, there will be no way to calculate the assessment. But you're talking about adjusting. They cannot, the fact that it says they may be adjusted doesn't mean that he shall adjust by the CPI.
Well, that means that they don't have to adjust it. But if they do, they got to use the CPI formula, doesn't it? They can't just arbitrarily increase the amount of the assessment based on, some whimsical number, right?
Well, my personal interpretation of this is that with the change in the pro rata, they want to take out the pro rata, then there's no methodology, no way to calculate, and therefore the...
What language do you think in the amendment changes the formula in Section 5?
What language do I...
Yeah, where does the amendment affect the formula for calculating the assessment? Directly to the language, you said your personal opinion. I'd like to look at the language. Which language are you talking about, Counselor?
I think it's easier to go to the defendant's answer brief to get that language.
Okay, well, I didn't mean to take a lot of your time. When you get to your rebuttal, why don't you answer that question for me? Why don't you go ahead with your argument? I don't want to
Okay.
take up a lot of your time looking for the...
Okay, all right, okay.
Did you have the right to, under the original declarations, did the homeowners have the right to pursue some sort of reimbursement once they had paid their dues? Did they have the right to reimbursement from the declarant at any point in time if there was surplus funds held by the declarant?
No, but Your Honor, the excess funds had to be used for the, again, magic words, the recreation, welfare, benefit, security of the residents.
But the declarant got to keep the funds. The declarant is a corporate entity, it got to keep the money. It didn't have any obligation to reimburse surplus to the homeowners, right?
It doesn't mean that he can take the excess funds and use them personally, and now that's what he wants to do. He wants to take the excess funds and use them for profit. And in doing that...
See, I'm not sure what the practical effect of that is, and that's where I'm unclear. The declarant, this is not a homeowners association, this is a corporate declarant that has been getting this money, and it may have been pooling the money, it may have been taking all the surplus monies and paying it to its principal as a salary. Under the original scheme, what would have precluded the principal in the corporation from increasing salary for the principal and absorbing whatever might have been what you characterize as profits? What precluded them from doing that?
Because, number one, there's absolutely nothing in the original declaration that says the developer may take a profit.
Well, but you didn't hear what my question was. It had to do with the developer paying its principal money, because it expressly states that they can use the money to pay for the cost of labor, equipment, materials, management, and supervision. I mean, they got a president of the corporation. Why couldn't they pay him $1 million if they had the money to do that after all of the maintenance was conducted?
That might be okay as long as the money is spent for the benefit of the residents, but it cannot be. That's why he's changing this. That's why he's taking out the section that he's taking out, because there's a great deal of money involved in the payment of those utility bills.
Right.
And as it stands right now, the residents have something to say about that. I mean,
Well, you said that before, and I heard you say it, and I didn't want to interrupt you, but I don't see how the residents have any say in a situation where there's no homeowners association, they don't have any participation in management, and the fees that they pay are, by virtue of the document that they originally signed, in the possession of the declarant to be used in the declarant's sole and absolute discretion on myriad things. I mean, how does the homeowners, if the declarant under this document is not spending the money, enough money to maintain the lawn nice and green in the wintertime, where under the original scheme do the homeowners have any right to say anything to the declarant about that?
As long as the declarations say, which they do say, there may be a reasonable reserve. The people who entered into these contracts had the expectation that they would pay for all these services, and if there is any left over, that would go into a reasonable reserve for their benefit for whatever needs there would be within the community. That's the reason why they've lost a benefit. See, the trial court found that no obligations had changed and no benefits had changed, and that's absolutely not true. The developer is no longer obligated to pay the enormous utility bills from the amenity fees. And not only is he not obligated to do so. He's not even permitted to do so, because that's a specific permitted use. It's in the laundry list of specific permitted
So do
uses.
the homeowners pay that now? Are they gonna have to pay that? or
The
what?
homeowners pay, yes, sir. There are many.
So they're gonna get a bill for the utilities for the common areas now, or what's gonna happen?
Well, the developer has the obligation to take part of the amenity fees to pay those bills.
Okay,
But now he's taking that out. He doesn't have that obligation anymore.
so has anything happened?
Nothing's happened yet because we're in the middle of a lawsuit. And so he's, first of all, we don't have any records from him. So we don't know how he's manipulating these funds. We only know what the declarations and the amendment says. And the amendment is taking away power, what little bit of power the residents had, and they're giving him carte blanche, absolute control over how the methodology, how the fees will be calculated, how they will be increased, how they will be used.
I don't see that part, but, it doesn't seem, it seems like he's still stuck with, the only way it can be increased is by the CPI.
No, sir. You promised me that in my rebuttal I can show you and read you that section.
We'll give you that opportunity.
Okay.
Did you say that the developer now, under the amendment, after the amendment, the developer does not have even the authority to use the assessment monies to pay for the lawns and all of those things?
He absolutely is not permitted to do that, because Article 6, Section 1, clearly lists the laundry list of the permitted uses that shall be paid.
Yeah, but all of that is a subset of what preceded it, isn't it? In other words, yes, the language in the first 3 or 4 sentences in Section 1 is so broad in terms of what the permitted expenditures may be, that the last sentence or two are essentially subsumed in that, aren't they? It says that the developer has absolute and sole discretion and can spend these monies for promoting the recreation, health, safety, welfare of the residents, constructing, maintaining, operating, repairing, replacing improvements on the common area, enforcing the covenants. It's all encompassing, right?
Which, it goes on to say, which includes.
Well, there's another sentence that says the assessment shall also be used for maintaining, and that forces them to do it, but I thought you told me that now they don't even have the authority to use those monies for that purpose.
Well, if it's no longer a permitted use, which it will not be because it's taken out of the shall be used. If it's no longer a permitted use, then he doesn't have the authority to take the amenity fee money and use it. And what he's going to do with the amenity fee money, the money that was in there to pay those bills will now be excess funds. And another change in the amendment was that the developer now gets to pocket all excess funds.
Counsel, you're down to a little over 2 minutes for rebuttal time. I'll give you 3, if you'd like to stop now.
Thank you. I guess I better.
Okay.
Thank you.
Thank you.
Good morning. If it please the court, my name is Pat Fulford. I represent the defendants, or appellees in this matter, who are the declarants and developers in the declaration, which is the subject of this.
What form of entity is your client?
I'm sorry?
What is the form of entity of your client?
Development and Construction Corporation of America, references DECA.
Is it a corporation? Okay.
That's a corporation.
All right.
And Oak Run Associates is a limited liability company.
Limited liability company, all right.
Yes, sir.
Let me get you zeroed in on
Sure.
my first concern, which is Section 1, the last part of Section 1 that was deleted as a result of the amendment did compel the developer to pay all of these things that are listed in there. It used the language shall, and that was deleted. I interpret it as now they may do it. Council disagrees with me about that apparently, but that does seem to be a material change. Where else in the declarations do you say you find the language that compels the developer to pay all these expenses?
If I understand your question, Your Honor, the obligation shall pay by the declarant, I think that's still present. The amendment did not change that.
I thought that language was deleted.
No, sir.
The assessment shall also be used for maintaining. Did I make a mistake there about that? Wasn't that deleted?
Well, I see what you're saying. I think it's redundant, Your Honor. It's exactly the same thing that's in the above section of Section 1.
Well, it's redundant to the extent, I agree with you that it's redundant to the extent that you have the discretion to use the funds to pay these expenses. But that does something a little bit different. That compels you to pay these expenses. Where in Section 1, as amended, are you compelled to pay these expenses?
Well, I think we're compelled to pay them because they're the common areas and the recreation areas that ownership is with the corporation and the limited liability company. So,
well, I mean, but before, you had to cut the lawn. You had to do it. You had to do it, even if you didn't have enough money from the assessments. Now, you can do it if you got enough money from the assessments, or maybe you don't. Maybe you let the lawns grow and the rats run around in there.
well, because maybe, Your Honor, because that is somewhat in conflict, the way you presented this to me, with the sole and absolute discretion for the declarant to pay these matters as he sees fit, that possibly the rural construction would read in that a reasonableness as well as previously mentioned in our briefs. But I think those things are mentioned, they're redundant,
There
they're
must have been
elsewhere.
some reason the developer wanted to take that out. What was that? Why did they take it out?
Your Honor, I wasn't present when they took that out. I don't think that there was a reason for taking it out as much as was the amendment they put in there to establish that the owners acknowledge that this was maintenance was paid not on a pro rata basis. I don't know of any reason they took it out.
Well, I'm just wondering whether they can. I'm wondering whether they can. I mean, you're not convincing me there's a difference between absolute discretion to do a lot of things and then some specific language that says shall do things. And to take that out means now that they can use the money that they were compelled to use to pay for these items, and they can use the money to pay their principal a higher salary, for example. Right? Doesn't it? I mean, what in there compels them or precludes them from doing that?
The provisions that are still present in Article 1, Article 6, Section 1, it says the declarant shall, that the assessments levied shall be used in sole and absolute discretion, and it lists a litany of items in there,
Right.
which include operation, repairing, replacing property, services,
But there's no
facilities.
shall language in anything before the sentence that was deleted, right? I mean, there's nothing.
sorry.
There's no shall. I mean, shall means something different than sole and absolute discretion, right?
Shall be used.
I'm reading quickly. I read it, Your Honor, that when it says even though absolute and sole discretion, it's still restricted to those items. Those items are encompassed in Article 6, Section 1 that was remaining as to the items that were subsequently deleted in the amendment. With all due respect, Your Honor, I don't see where there's a difference that he has now been relieved, the declarant has been relieved of that responsibility.
All right, sir.
Is there any meaning to the word also? The assessments shall also be used for maintaining?
That's what the language says, yes.
Well, don't you think also means that there is something here in the following provision that is different from what preceded it?
I guess it can be interpreted that way. I don't see that as relieving them of that responsibility because it says also be. But I do see the language, I understand your question, Your Honor.
So your position is that you are still compelled to take care of all of that even after the amendment?
Yes, sir, absolutely. I think that nothing...
And if you aren't, if you're not, then you lose.
If I'm not, I lose, but if they don't take care of that, and the homeowners will bring a cause of action for a breach of this agreement, this declaration, I think if they weren't doing what they're supposed to do, then they would have that remedy available.
Now, the amendment language, owners acknowledge that the payment of this assessment is for a fee, blah, blah, blah. I mean, you know, y'all just made that up, right? I mean, they didn't acknowledge anything. You just did a unilateral amendment and...
I think, Your Honor, if it's trying to show that this was not a pro rata scheme. It never has been a pro rata scheme. You're looking at payments that are made annually in advance of the services being provided and the operating.
I'm not sure that I disagree with you about that, Counselor. I'm just wondering why the amendment was even done if it doesn't have some effect on the... It's
not in the record, but you want my opinion?
No, I just want the record, yeah. No, I mean, you can tell me, though, what that language does, if it does anything, to change what preceded it.
I don't think it changes anything, Your Honor.
Yeah.
I think the declaration pre-amendment is absolutely the same binding agreement as post-amendment. No, I don't know why they did the amendment, but I don't think it changes any of the obligations of the declarants in providing the services.
Well, I mean, this part about retaining excess amounts, the declarant always had the privilege to retain excess amounts without expending it on any of the enumerated items, right?
But I think what they're showing here is that this is not a pro rata scheme. It never was, that it was a payment for services being provided, and the costs and expenses were going to come out of the amenity fees.
Right.
Any excess would then be able to be retained by the declarant, be able to use for other matters that are set forth in Article 6, Section 1, such as repairing, construction, new construction, all the litany of items that are listed there.
Is counsel, your opponent said that under the new scheme, somehow the fixed assessment amount is no longer fixed, that the developer, as I understand her argument, that the developer can now modify that in a way other than by use of the CPI formula. Is that true?
No, sir. I read that differently. When I see the word may in there, I read that as the developer may increase or decrease.
So the developer is, if the CPI goes down, the developer is not obligated to decrease the amount.
No, sir.
But if the CPI goes up, the developer may increase the amount, but only under the formula.
That's how I
That's the way you interpret it.
That's how
There's nothing in the amendment that changes that.
Does not change that one bit.
Okay.
Mr. Fulford, this happened in 2005, right?
The amendment was 2005, correct?
And then it was much later that suit was filed, right?
Yes, ma'am.
Do we know what happened between 2005 and 2010 in terms of the assessment and what happened to the money?
It goes into a general fund, Your Honor, and then it pays for everything else that's going on there. There's no accounting, and that might take us to the other issue that's before this court as to whether there is under Chapter 720, 3086, a financial reporting requirement for these declarants, which we submit they are not, and the trial court ruled that it doesn't apply retroactively. But to answer your question, we know what happened with the money. It goes into the general fund and it pays for all the amenities and all the services and things that are provided.
Well, what do you think is the meaning of the language, declarant is entitled to retain any excess amounts collected from the owners over cost and expense?
Cost and expense for providing those services. So that gives them the additional funds necessary to do new construction, for recreational or common areas, replacing of any items that need to be replaced. But what they were talking about is the cost for the services provided. And so it's not like the money is, and even the trial court ruled that those monies are still there available to provide for the other required maintenance and items that they go with the community.
What does such services refer to?
What were the services?
Yeah, it says such services. What are such services?
I would say that service would include guard security. It would include the lawn service, the maintaining with there's swimming pools.
Well, such is a word that means that we're referring to something else. I'm trying to figure out where in the document I find what it is it's referring to.
I don't know that the document says where it's referring to, Your Honor. But throughout, these were 3,200 homes, 25 neighborhoods. The neighborhoods have their own rec areas and swimming pools, and all these things are maintained throughout the use of these amenity fees. So those would be services and taking care and maintaining those items as well.
Mr. Fulford, did
Yes.
the fees go up in this 7-year period? Or, in other words, did somehow the developer raise the fees in some manner other than it was in this declaration?
I don't believe the fees have gone up, Your Honor, primarily because the CPI has not really increased by much.
Well, that's, I mean, their position seems to be, well, now, you know, the developer's not gonna pay for utilities and all these things related to the common rec areas, and that maybe they gotta pay for them. And my question is, did somehow the fees go up in some way other than set forth in the declaration?
No, sir, they did not go up. They did not go up. And the services that the parties were receiving since 1985, when this began, they're still getting the same services today. It's a speculative argument by the owners in this matter. And I provided in my brief also that if in fact there was a breach of this agreement, this declaration, the owners have a cause of action. They have a claim they could bring if such were occurring. But what they've brought is a speculative claim, what might happen. And we submit to the court that this amendment wasn't necessary, it didn't change anything, it was really to...
Somebody thought it needed to be done, evidently, for some reason. If it didn't change anything, why would you do it? So, I mean, this is suspect under that, you know, kind of theory.
Some of the homeowners believe that it should have been a pro rata, and they were entitled to be seeing what the expenses were, and
So it was in response to some sort of claim that the homeowners made?
yes, sir. And they were claiming they were entitled to Chapter 720 homeowner association type of requirements, and that's just in the case in our position.
Is it your position that the statute only applies to for-profit, not-for-profit corps?
That was a misword, but what the statute applies to are the homeowner association, not-for-profit, that run or regulate homeowner, community, residential communities. I think when I read into that statute, because in 1995, when the statute was enacted, it made a provision in there that the developer, at the completion of the project, when he's 90% complete, he had 3 months to turn over to the homeowners association, which was a not-for-profit association, and they would then be required to turn over the common areas, the recreation areas, basically making and telling in 1995, if you do a development, you as a developer do not get to keep those properties because this statute controls. Because we were before that statute, the declarant and the defendants in this case, they own those properties, and they continue to own them. And the ownership is, and these assessments and what they charge is to keep those running in addition to other services, swimming pools, things of that nature. So maybe I got off a little bit, but the whole point was that the statute does not require, in our view, the financial disclosure. And because they weren't given that financial disclosure, homeowners were saying, we want to know where the money's going. And so this amendment then was a sort of a, this is where it is you acknowledge it's not pro rata, you acknowledge any excess, and I agree with Judge Torpy that it really has no, they don't agree with that, at least the plaintiffs in this suit, they don't agree with it, so it doesn't have a meaning.
I just want to be clear on one point, because
Yes.
I don't want to be operating under a misimpression here. Your contention that the developer is still obligated for maintaining the lawns, let's use that as an example, is based solely on the language of Section 1 of the declarations, right? In other words, the broad introductory language in Section 1. There's no other place in the declarations where the developer undertakes that responsibility.
Your Honor, I think there's a list of things that are requirements of the declarant, and it would be under Article 8.
Oh, Article 8, okay.
And it's entitled maintenance, and then there's one paragraph says maintenance by the owner, which owners being the owners of home sites, and then Section 2 is maintenance by the declarant, and in there that has all the walkways, parkways, lawns, shrubs, all that. So there's, in Article 8, that still shows that they're responsible for paying that.
Okay, all right, well, that's what your opponent said, and I was surprised by your comment that you were relying on Section 1, so, okay. All right, I understand, sir.
I think my point, Your Honor, is Section 1 in the amendment didn't change the obligations.
Well, it did change the obligation, but it didn't change the authority. It changed, Section 1 took out the shall. I mean, shall, and as Judge Griffin points out, shall also, I think, is in there too, that, if it's somewhere else in the document that they still have that responsibility, then maybe it didn't have an effect on the document as a whole, but it sure did change Section 1.
In addition, I'd like to respond about the utilities for the common areas and the recreation. That's also provided for, Your Honor, and it's redundant as well, but that's provided under Section 8, Section 3. And in there, it's talking about that the declarant has the right to have public or private utility companies come in and service the properties, and they might bill the homeowners for those services if they do that. That's only reflective as to the home sites, not as to the common or the recreation areas. And I think if you look at a term of reasonableness in that, there's no utility company that I'm familiar with that's going to bill somebody, a homeowner, for somebody else's property and expect to be paid if the homeowner doesn't agree to the services of the utilities or what have you. They're not going to get those utilities. So what I'm saying is that clause, she's arguing that now puts the burden on the homeowner to pay those utilities.
Well, but if the developer, the declarant doesn't pay the utilities and they cut them off, then the homeowners without the benefit of the utilities on the common areas, right? They wouldn't have to pay it, but they don't get the benefit of it.
And that would be speculative if that didn't occur. I mean, that'd be speculative, they would have a cause of action.
Well, if you got a tennis court there and it's got lights on it and you're supposed to pay it and you don't pay it, they cut the power off, then the homeowners don't get to use the tennis court lights, right? Somebody's got to pay it, right?
Yeah, but that's right, but the owners don't pay it.
Well, let me ask you this question then. Given that hypothetical, if you represented the homeowners, where would you go in this document to require the developer to pay those things, including utilities?
I'd go to circuit court, I'd file an action.
I meant where in the document?
Where's the document that,
Where in the document would you go to point to when you went to circuit court to say this is why they're required to pay those utilities?
on the utilities? I think because it says operating, that would be reasonable to conclude that.
What section you talking? Just give us a section.
Yes, Section 1, sorry.
Yeah.
The old top part of section 1?
Yes, ma'am. Now, I think it's because operating certainly is a reasonable construction, and of that would be to include.
Well, it sounds like your position is that the part of the language in section 1 that was deleted really doesn't make any difference to your client if that's put back in.
It doesn't make any difference, Your Honor.
Yeah, the real purpose of the amendment was to communicate to the homeowners that if there's money left over after they pay, the declarant gets to keep the money and doesn't have to account for it.
He does not have to account for it, but he can use those monies for other matters.
He can pay his principal $1 million a year.
He could certainly do that, and there'd be no accounting because he's not subject to Chapter 720, 3086.
And explain to me again why that statute doesn't apply to you?
Our position, Your Honor, is that we had a vested right in confidentiality of our records, our financial records, we being the corporations, and that they're not open to public scrutiny. What this now does is tell the declarant under that Chapter 720, 3086 reporting, you have to show us where your monies are. You have to tell us where these fees go and where you spend them. And there's proprietary matters involved there, but that's a vested right of confidentiality that this statute in 1995 should not be applied retroactively because it's not a remedial statute.
But you agree that for anything that that arose after 95, that the statute would apply in your situation?
Well, our vested right to confidentiality is still the same whether it's 1985 or it's 2013. Those are all private records. And
well, let me restate the question. If this development had occurred in 96, then you agree that you would be subject to the statute?
And if this development occurred in 1996, they developed it, the platted and all that, then they would know that once they're 90% built out, they're giving up their common areas or giving up their recreation areas. They were having to give that over to the not-for-profit homeowners association, who will now run that community. And they have to run that community all in accordance with Chapter 720. But that's not how this community is because it before that. Does that answer your question, Your Honor?
Yes, sir. I think it does.
Obviously, I'm over my time limit also. I thank you for your time. If there's any other questions.
No, sir, thank you.
Thank you.
Thank you, Mr. Wolf. It says 2, I'll give you 3.
If it please the court, I'd like to respond to your question, Judge Jacobson. When you ask him, there's a reason why the developer took that section out about the utilities, and the reason is this. When he did that, he took away the right of the citizens to have any say-so whatsoever in the lawn and the landscaping and how it was being maintained. And he put it in his responsibility, his personal responsibility, which means...
Which is where? Tell me where that is.
Which is section...
Is that Article 8, Section 2 that the council refers to?
It is it's Article 6, Section 3.
Article 6, Section 3? Okay.
Yes, sir. It is the second paragraph.
Okay.
The last sentence, where he says, he shall instead be obligated to pay costs and expenses properly incurred in excessive amounts collected from owners other than the declarant for regular annual assessments. So you think, well then, okay, they're going to be covered anyway. But it's a very clever, greedy scheme here. And if you take those excess funds, and we're talking about a lot of money, and don't take them out of the amenity fees, and take the amenity fees and make them excess fees that you take then as profit, but then you agree to pay those bills anyway, but as a personal bill, you can start reducing those bills. And the way you reduce those bills is to reduce services. And when that happens and the lawn starts to die and the place is not beautiful, you are working against the interest of the residents. And this entire declaration is for the benefit of the recreation, the beautification, all those words we talked about. And so he has taken away a right of the owners, and he has changed his obligations completely. So I maintain that he took it out, but, I mean, why did he choose that one? And why didn't he put another article in there covering that one? It's because that's where the excess funds are coming from. The excess funds are coming, and a large amount of them in his pocket. So now he says, okay, well, I'll pay it, but he then has the right to control how he's going to do the landscaping and the water and keep those bills down.
What I heard Mr. Fulford say was that those excess funds have to be spent for the purposes in Section 1. In other words, is that right?
It cannot be right, because it says there may be a reserve account, may. And so that leaves it up to the developer to spend those funds any way he wants to.
Well, as I understand what Mr. Fulford was saying was that when it says the declarant is entitled to retain any excess amounts collected from the owners over cost and expenses in providing such services, that overage would nevertheless be required to be paid for those remaining general categories in Section 1. Is that their argument? I mean, that's what he said. You don't think that's their argument?
No. And I have to tell the court that his argument today about the retroactivity, the trial court ruled for us in that regard, and he did not cross appeal, so this court doesn't even have jurisdiction to hear that. That issue is dead. I mean, it's been decided that they do fall within 720. But the most ridiculous thing is that they have gone back and created an event, which is the beginning of the creation of Oak Run. They're saying that is the event that fits within the legal change. In other words, if there's an event occurs that the new statute would cause a legal change substantively, then you can't retroactively apply that statute. So
you've exhausted your time.
Okay,
We
thank
got
you.
your point.
Thank you.
All right, we'll be in recess.
Thank you.